Ready to proceed with their first case, which is State versus Price. And each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. And just let me know if you don't care.
Thank you, Your Honor.
Try to save you some time.
I'm Wesley Johnston, attorney for the appellant. I would respectfully reserve 5 minutes if I could, Your Honor.
Thank you.
This case involves child pornography. This case is a case that was tried to the bench. My client was convicted of multiple counts of publishing child pornography. And the facts of this case are, I think, what makes this case unique. My client was convicted of using a computer that was in a bathroom. Now, this computer was, of course, not established that he had purchased this computer. There's no evidence of that. And it's not established, frankly, that he owned this computer. What was established was that on this computer there was a picture of one of his old girlfriends in a couple undressed. There was some trace searches that were used that referenced his name.
Well, they said there were thousands of them.
Your Honor, there was references to other people during that search done by the forensic evaluations. In this case, there were other people that were referenced. If I recall, his old girlfriend was referenced. Your Honor, his brother was referenced. There was multiple other references used on this case. The thing about this computer, frankly, and one of the things that they're talking about is that someone who was staying at the residence testified that when she left that morning, the wallet of my client's wallet was not on the computer, and when she came back after dropping off her child, the wallet was on the computer. And that's a big thing. Somehow that shows that my client had somehow used it during the time, was operating it during the time, and I respectfully submit that that doesn't show anything of that nature. Frankly, that woman testified that my client's wallet was in that bathroom for some time before. The testimony is that she had been there for a year, and the testimony was that the wallet had been, that his ID had been there for some time long before that. So it's nothing, frankly, unusual that his wallet was in that bathroom at that time.
I thought the testimony was, though, that the computer was off, and then when she came back, the computer was powered on. Pornography was, it had a window open for that, and then that the wallet was there as well at that time. Maybe I misunderstood, but that was my...
No, Your Honor. I think that's some of the issue of this case is how the testimony came out and what was actually said. My recollection of the testimony is that the computer itself was powered off, that it was supposedly hot to the touch, but that there was a wallet, there was a white T-shirt, and there was, I can't recall right off the top of my head, on top of the computer. But the thing about it, that when they opened it up, they made a big deal about that there was pornography. Frankly, it was adult pornography. There was a Facebook, which there was no testimony about who Facebook was, and there was supposedly Aries, which is the child's sharing system, was maximizing in the background. Your Honor, I think there's testimony that came out subsequent to that would, at least from my client's expert, that said that they messed up. They messed up when they opened up this computer, and that they basically destroyed whatever was possibly that they could have seen on the computer at the time. They can't find it because they powered it down. They did something wrong.
They being who?
They being the police. Because my understanding, my client's expert testified that when the police examined this computer, that they made mistakes in terms of examining it, and they eliminated any and all evidence that they could have acquired at the time.
So there would be no indication on the software at what time it was last opened?
I don't know if I could say that, Your Honor. I think that there was no evidence at that time whether or not there was, frankly, whether or not the Aries was seen or could be seen by anybody who was operating that vehicle at the time, whether there was any child pornography occurring at that time. So that's where I would say.
So that you're saying that where it says when and this is the Apley's brief, where it says, when police opened the laptop, they found open programs with maximized windows. On the screen were open windows for Facebook, an adult website, and behind those windows with a third screen was a peer-to-peer file sharing program with errors. So there was 3 open programs, they're saying, and the officers saw that it was running with an active search for a term. Is that your recollection as well, or is there something there that?
That's my recollection of what the police officers testified as to
Okay.
what was seen at the time. But what I'm suggesting to the court is that doesn't establish anything with respect to my client.
My question on that would be, was there a password protector on that computer that was known only to your client, or was everybody, did everybody know what the password was to log on?
Your Honor,
What's the record on that?
the record on that is that there's absolutely no password on this computer. That everybody had access to this computer. Everybody, frankly, I won't say everybody, but there's testimony that multiple people in this house use this computer. There's no password protection on this case, and they were all default settings on this case. So, and that's really where I think this case gets to. This case is built on, of course, circumstantial evidence. And one of the cases that I recall from this court is a case called State v. Roar, which I remember well and I've read many times. And the interesting thing about that case is it establishes what circumstantial evidence can be based upon, and it can't be based upon speculation, and it can't be based upon conjecture. And this is not a possession case. So this is not a situation where we're dealing with constructive possession or anything of that nature. So this case, there must be more than what we have here. We basically just have a wallet on top of a computer. We have clothes. We don't have any testimony that those are his clothes. We don't have any testimony of that nature at all. So it's conjecture, it's speculation. I would submit that it's what they want it to be, but I don't believe it's sufficient under the law that was established by this court in State v. Roar and subsequent to make circumstantial evidence sufficient for conviction in this case.
Is the transcript going to show there was other people in the house at that time other than Shirley Toner and her son?
Yes, Your Honor. There were other people at that house at this time. There was my client's...
At 8 o'clock that morning?
Yes. Yes. There was my client's mom was downstairs. She was at the daycare. There was my client's brother, Johnny. He was also downstairs. The father, I'm struggling with in terms of trying to recall whether or not he was there at the time. He worked, so I can't recall for the record whether I can. But I know that there were multiple other people at this house at the time.
Was there? It's my understanding that the bedroom that Mr. Price came out of was adjoined the bathroom. There's a doorway that went into the bathroom from his room. Did he share that room with anyone else?
Yeah, Your Honor, that's another thing that's interesting about this case. My client actually slept downstairs on a couch, and really, frankly, did not have a room. When you talk about sleeping, he mostly slept in the basement, downstairs on a couch. That's what this woman testified to, who had lived there for about a year. She testified that mostly he slept downstairs. With respect to the adjoining room to the bathroom, some testimony came out that it wasn't Brandon's room that was connected. It was actually Johnny's room, the other brother's room. And the thing about Johnny's room is that Johnny had a fiance too. So there was conflicting testimony. I think they're trying to identify this room as Brandon's, and I think the testimony is disputable on that. I think they're trying to establish that this was a bathroom that Brandon used exclusive to everybody else, and the testimony is most definitely exclusive to that. Everybody used this restroom, this bathroom, and then there was a lot of argument about whether or not my client can actually use his argument. I don't think the defense, we didn't concede that. So there were some questions about the facts, whether or not this was a bathroom that was used regularly, whether by everybody, and it was, whether or not this was a computer that was used regularly, and it was, whether or not it was all types of issues, Your Honor. Because I think this
Counsel,
came-
and you are in your rebuttal time, if you'd like to.
I will withdraw. Thank you, Your Honor.
Good morning, Your Honors. My name is Matthew Kern on behalf of Dean Holman, Medina County Prosecuting Attorney, and I represent the state of Ohio in this matter. I guess I'll start with the first two assignments of error, the sufficiency and Rule 29 denial assignments of error, which I think I've grouped for the court's consideration. If I can, I'd like to focus the court's attention on there are two aspects that the defendant challenges here. One is the identity portion, which we've spent most of this morning talking about already. And I think there are a few facts from the record that kind of establish why a rational regard of fact could find that the state had proven its case beyond a reasonable doubt. And those are specifically the computer searches of the Samsung computer issued here, both by the state's forensic expert, Officer Merrick, and by the defense expert who was retained with court assistance. The defendant's name came up in search results thousands of times. The closest person who came up after the defendant's name in searches of the computer was the defendant's former fiancée. And her name came up maybe 100 or so times.
And did her name come up close to the date in which the offending material was seen on the computer?
I don't think the record contains the dates of when those results came. The record shows that the name came up a lot in connection with Facebook results, and both the experts testified that they couldn't tell if that was the result of a person going to that person's Facebook page or that person using Facebook. So actually that number is arguably inflated over what its real use would show. Now, Shirley Toner, who testified as a state's witness, who lived in the house, who was the woman who established that when she had her son up in the morning at 8 o'clock that morning to get him ready for school, that the computer was not plugged in, it was not on, it was sitting on the corner of the sink with nothing on it, it was in the corner. And then 2 hours later, when the police show up and execute their search warrant, the computer is plugged in, there's Mr. Price's property sitting on top of it. We know that because it's his identification card in the wallet that's sitting on top of the computer. She testifies that nobody else in the house used that computer, that it was Brandon's computer. So her testimony establishes that it's Mr. Price's computer because nobody else used it. She said that she and her living boyfriend at the time, who were in a room on the right side of the hallway as Officer Hayes came up the stairs, had a tablet that they used. They didn't use the computer in the bathroom. And nobody else was upstairs when the officer came up the stairs on executing the search warrant to secure the house. Ms. Toner and her boyfriend were on the right side of the hallway. They were secured in their room. They were not anywhere else upstairs when the officer came upstairs. Mr. Price, however, was, even though Shirley Toner testified that he slept downstairs on a couch regularly. So that morning, he came upstairs, was in the area of the bathroom where the computer was found in a different state from 2 hours earlier, had access to the computer. His wallet's on the computer. The shirt and the belt are man's clothing items. They're found on top of the computer, and the computer is running. Now, yes, there was some evidence presented at trial that the computer had been purchased by Mr. Price's mother, but Mr. Price is a relatively young man. It would not be unusual for a relatively expensive solid-state hard drive computer to be purchased by a family member. But the evidence at trial showed that he was the only one who used it, and his items were found on top of it. In terms of identity, the fact that he's the one using the computer and running these searches and publishing these images, I think was relatively well shown. The other issue raised by the defense is regarding recklessness. The Aries computer program that's running in the background, the third screen behind Facebook, behind the adult pornography website, the third screen that is an open maximized window, which is not Aries network default, is running an active search, also not the program's default. And it's using files, it's sharing program files in the program, it's sharing files in the shared folder to anyone else on the Aries network. That's how ICAC, the Internet Crimes Against Children Task Force, was able to download the images using their special forensic software, was able to download the images before they executed the search warrant. So to say that he's not publishing these images is a bit of a misnomer in light of the record evidence. Both ICAC, another township police department, and the U.S. Secret Service, all independently, because they didn't know of the others' investigations, had downloaded images from this particular computer with these specific hash values. So yes, files were being shared. That's sufficient under this court's jurisprudence, specifically State v. Christian, which we filed supplemental authority on, 2015 Ohio 1720. That's sufficient to show publication if the files could have been shared. In this case, they were in fact shared. The issue regarding recklessness is whether he knew or should have known or was perversely disregarded a known risk that the files were being shared. But the testimony at trial by Officer Merrick specifically was that Aries gives you a specific notification that your files will be shared. And in fact, it requires you to share files. Otherwise, in Officer Merrick's terms, it blacklists you. If you don't share files on Aries, they don't allow you to use the program. It's the entire point.
Does the person wishing to use the program have to do anything discreetly before the files begin to be shared, or is it automatic?
So that particular question is not necessarily covered by the record. However, what I would say in response is, once a person downloads files using the Aries network, those files are stored in the user's shared folder. So,
And we have testimony to that effect?
yes, Officer Merrick testifies, and I think Agent Furtari of the Internet Crimes Against Children Task Force testimony also establishes the normal practice of how Aries works. Once a user downloads the image from another user, that image, rather than being stored on their own hard drive, well, yes, it's stored on their hard drive, but it's shared as a different folder. Aries accesses the shared folder instead of the entire computer to then make that image available to other users. So essentially, Aries is making multiple copies of the same file, which then it has a wider area to distribute that file. So if 4 people download an image, but 3 of us turn off our computers, the one person who still has the computer turned on with the file in the shared folder, it's still retrievable by millions of other users of the Aries network. That's how the shared peer-to-peer network software works. If I could, I'll move on quickly to the other assignments of error in order. The third assignment of error regards the witness list issue, specifically Officer Hayes of the Brunswick Police Department not being on the state's witness list initially. That was admittedly an oversight. The state admitted so during trial. We provided a supplemental report before trial. We received a supplemental report from the defense at the same time, transcript page 13. The court gave defense counsel an opportunity to talk to the witness during a recess, and then later inquired, are you satisfied? Do you want a continuance? I can give you a continuance. It's a bench trial. We can come back in a week, whenever. Transcript page is 121. Defense counsel said, no, I don't want a continuance. I just want to proceed. Transcript page 122. So in light of the fact that defense counsel had an opportunity to talk to the witness about what the witness's testimony would be before the witness testified, was satisfied with his ability to question the witness and wanted to proceed with trial, the trial court did not bless you. The trial court did not err in granting an opportunity for a continuance and fashioning the least appropriate sanction consistent with the Supreme Court's decision in State v. Darman. The trial court followed Darman to a T. In fact, the state cited Darman when the discovery violation first came to light and said, this is what you should do. The court took a short recess. Both sides investigated the issue, and the trial court fashioned the least appropriate sanction it thought necessary under the situation.
And the highest, he was the attorney, he was the officer that found Mr. Price upstairs in the house.
Correct.
So he's not really a surprise witness.
No, in fact, his name is, I think, should be mentioned in some of the other reports that were provided in discovery. And certainly by the time the state had provided the supplemental report before trial, that was abundantly clear. Also, the officer's testimony was limited to that particular issue. He was not involved in the prior downloading of the images through ICAC. He was not involved in any of the computer forensic examination. His role in this trial was limited to, he came up the stairs, he secured Ms. Toner and Ms. Toner's boyfriend into their bedroom, brought them downstairs, and saw that Mr. Price coming from the left side doorway where the bathroom with the computer was. That's the extent of his testimony. And I think that's why defense counsel determined that he didn't need to stand on the objection, that it really wasn't going to make life any easier for everybody to come back in a week. So, move on to the last assignment of error, the ineffective assistance of counsel portion. There's really two parts of this claim as I see it. The first is about not maintaining the objection to the testimony of Officer Hayes. And I'd say that really there's a strategic reason why counsel didn't stand on the objection, and that is first, defense counsel had their own late disclosed discovery that they were turning over, transcript page 13, so it was actually strategic for counsel to try to have their own evidence potentially admitted to the extent that they wanted to rely on that. It was strategic for them to kind of overlook or not stand on the objection for the state's admittedly late disclosed information. And there's no appreciable benefit for counsel to stand on the objection. The best that happens, the trial court's going to fashion the appropriate remedy, maybe grant a continuance, but all you're doing is delaying the inevitable. The officer's going to be allowed to testify. Standing on the objection isn't going to change the result of the third assignment of error in terms of the officer's the discovery issue. State versus Pennington, the 8th District, the court found that counsel was not ineffective for failing to seek a continuance when the witness was not on the witness list. This is a trial tactic. This is the definition of a trial tactic. It's not deficient performance. And the second issue in this claim regards the failure to present phone records. By definition, because they weren't presented, they're not part of this record for appeal. So because they're outside the record, you really have no ability to say counsel's performance was or was not deficient, or Mr. Price was or was not prejudiced. Under State versus Coleman, you should decline to address this portion of the assignment of error and direct Mr. Price to file a post-conviction petition if he feels necessary. Unless the court has any further questions, I think that each of the assignments of error lack merit should be overruled.
Thank you.
Thank you.
Thank you, Your Honor.
You have just a little less than 5 minutes.
Thank you, Your Honor. I do have some questions, Your Honor, with respect to who, frankly, used this computer. There was evidence on the record that other people other than Brandon used this computer. And that's, frankly, established by the results of even the state's witness who testified that there was other people in the searches. Their main witness in this case, the female who resided at this residence, testified that she saw other people use this computer. She saw Johnny use this computer. She saw 2 of Brandon's old girlfriends use this computer. So there's multiple people who were using this computer at this time. Obviously, there's no issue with respect to the ownership. That frankly is not, it wasn't his computer. They didn't even suggest that they purchased it. They didn't even suggest to argue that there was no evidence of that. With respect to the issue on Officer Haas, and I may be butchering his name a little bit, what happened in this case is that the state defense was provided with a supplemental report on the day of the trial, and the defense looked at it and indicated that, well, if you don't have, well, I'm looking at this, and I think I may go to some ownership issues. It is on transcript 13. If you don't have a problem with mine, I won't have a problem with yours. But what that doesn't say is that I'm not agreeing to this guy being a witness in this case. And that's 2 different things. You may get a report from a police officer, or you may get a statement from a witness, or you may get a statement, an expert report. That doesn't necessarily mean that person's going to be called to testify. It's not on a witness list. There was no supplemental witness preside in this case, and that, I think, is the issue for the ineffective. This was the only person, when you look at that report, or when you look at, this was the officer who put my client coming out of the residence.
Is there, excuse me, is there open discovery in Medina County?
There's not open discovery in Medina County. And this is the one witness who puts my client where coming out of that area location, the only one. And the supplemental report, when he looks at it, suggests it. So that is a real problem. That's something that, and then the court, what the court should have done is said, I'm going to restrict this testimony, or not put the defense into a situation whereby it has to either decide to allow a case to be continued, which it does not want to be, and force the defense to go to trial on a case with a witness that shouldn't have to. What it should have done is what the defense requested it to initially, is keep that witness and not let that witness testify. Then go keep the trial going. That's where I have an issue with what the court did, and that's where, of course, I have an issue with what the defense attorney did. And that is, when you have one witness in this case, who's a police officer, who puts my client coming out of a location at a residence, that is the case. So there's no other witnesses who could do that. The woman who lived in the place, she couldn't even do that. She was sleeping. So I respectfully ask this court to reverse these convictions. Thank you, Your Honor.
Thank you, counsel. The court will take the matter under advisement, and a written opinion will be prepared and sent to both sides. And you can also check on the website. So thank you very much.
Thank you.